limits because there's no point giving long sermons and not having teeth or not having a remedy. No point giving rights without a remedy.
27 days, including those 2 days.
Yes.
There is somebody who's competing with me on the mic. Anyway, 200. When a bill may I read, Malas? When a bill has been passed by the Legislative Assembly of the state, or in the case of a state having a legislative council, has been passed by both houses, it shall be presented to the governor. Now, note this, Malas. Three options only. And the governor shall declare either that he assents or that he withholds. Now, withhold is covered in the proviso. Or that he sends it to reserves the bill for the considered president. Only three. The second one, they elaborate by saying that if you send it back and the legislature sends it back, then he is bound. Now, here the error of the argument of one of the learned counsel in the morning is to omit the fact that the governor has never sent it back. I hope I'm clear. The governor has never sent the 7th March bill back. 17th March bill sent on 22nd March back. The question of the legislature sending it back will not arise. Therefore, now the paras of Justice Paniwala's judgment kick into action straight away. Please hand over the compilation, page 1831 it starts, volume 3, volume 4. And the whole purpose of this law was that you cannot paralyze state administration because you are second guessing the governor and the council of ministers. They have the right to do right, they have the right to do wrong. The electorate will deal with it or judicial review will strike it down. The governor can't withhold endlessly without declaring, without sending back, without sending anywhere else and sit on it. Squatting is not an option. Squatting on a bill sent to you is not an option. If you squat, then 1 month later, the bill is deemed to be passed. In this volume, it starts at 1831.
1831.
I will read 3 paras and the conclusion. May I read, Malas?
Yes, yes.
It's a long, detailed judgment. The bench labored hard and wide and across the globe. All precedents, entire Constituent Assembly debates. It's a very, very well written and a very comprehensive judgment after considering everything. And we argued it, Malas, over a period with the Monday, Friday interruptions of over 2 months. Now let us come to 3 paras in sequence, only 3, and 1 conclusion, 4 paras. First is para 240.
Yes.
That is at page 2037.
Yes, yes.
Thus, it is important to take note of this very fine but pertinent distinction that the prescription of a time limit by this court into 200 of the Constitution does not fundamentally change the procedure which has been envisaged. While the reading in of a time limit under 200 would have meant that there would be deemed assent upon failure of the governor to comply with the set timeline. The prescription of a reasonable time period does not introduce any such mechanism or deeming fiction in Article 200. Well, I would beseech my Lord that repay study. I'm not reading in detail. Lordships can certainly read in detail. I'm only reading 3 paras, but it's something which really repay study. And I'm not doing justice to it by not reading it in detail. Then, Malas, they say that this is not creating a new mechanism which is beyond the Constitution. It is fulfilling the Constitution. And they then do it actually in para 250 at page 2043. 250.
Yes,
the actual
yes.
timelines. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Prescribed, not optional, not suggestive, not recommendatory, mandatory. Failure to comply with this timeline will make the inaction subject to judicial review. In case of either withholding or assent or reservation for the consideration upon the aided advice. the governor is expected to take such an action forthwith, subject to a maximum period of 1 month. That is the category for us. The return of the bill has not happened. That is the second category of 3 months. Wrongly told to your lordships. That is para double I. There is no return of the bill. I'll tell you why also when we discussed this in practical terms and we argued the matter. Governors choose sometimes not to send it back, because if I send it back and the legislature sends it back to you the next day, then you are bound.
We have 2 questions. I've heard you
Yes.
quite length of, in fact, 3.
Well, it's just 5 minutes more and I'm done. 5 minutes more.
Very well, very well. You can.
This judgment ends at page, the relevant part of this point ends at para 435, just above 436 at page 2240. That is para 435 bracket C at page 2240.
40. Ask what.
Yes.
And this is not the first case. It followed upon Punjab. There I had the privilege of assisting the court in Punjab, and this Punjab is followed here and applied here. Having regard to the unduly long period for the time in which bills have been kept pending by the governor before the ultimate declaration of withholding of assent, in view of the scant respect showed by the governor to the decision of this court in state of Punjab, and other extraneous considerations that appear to be writ large in the discharge, we are left with no other option but to exercise our inherent powers under 142 for the purpose of declaring these 10 bills as deemed to have been assented on the date they were presented after being reconsidered by the legislature on 1811. That's the operative part. And the conclusions are subpara 9, small Roman 9, at page 2222. There is 2222. There's a long list of conclusions, if your lordship notes, it starts at 2218. 2218. If my lord will just turn to 2218 and note the first one. The 3 options are given. Only 3, no 4th option of just spotting. There is no 4th option of spotting. There are only 3 options at page 2218, para 434, small Roman 1. Assent, withhold assent, or reserve. There is no 4th option. Then, your lordship sees small Roman 9 at 2222. This is the law of the land now. The bills having been pending with the governor for an unduly long period, the governor acting in clear lack of bona fide and reserving for consideration immediately after pronouncement, are deemed to have been assented to on the date they were presented to him after being reconsidered. Then, as I end, just one point, I'll be very sorry, I'll just await your lordship's query after that. There is a general principle that your lordship, even if the act was challenged directly, does not stay the operation of an act, except in exceptional circumstances. Your lordship is aware of the principle, cases have held it repeatedly. Here, without the act being challenged, the inexorable consequence of the act of geo is sought to be stayed on the last day of before coming into force, and your lordship should not even say subject to outcome, is the case of the petitioner. There is no operational fetter or stay on the judgments of the Supreme Court in Punjab and Tamil Nadu. The misleading impression given by certain advisory opinions which have been referred, there has been no stay and there is not an appeal. There is no intra-court appeal in the Supreme Court. The Supreme Court is final. It is right because it is final. It is not final because it is right. Ultimately, you may go in reviews and curatives, but it is right because it is final, and there is a finality attached to it. Those are my submissions. I would at the end beseech my lords to not nullify such a detailed, well thought out, intensive, analytical, bona fide exercise in the prerogative of the elected members across the political spectrum, all of whom believe that this is good for a state, by an interim order before completion of pleadings without final hearing at this stage, and most of this can be achieved by making it explicitly subject to the outcome. I'm done, I'm very sorry I interrupted your lordship. Lordship will put those questions to me.
There were out of number of points that were urged on behalf of the petitioners,
Yes.
I would pose the 3 points which we feel you need an answer to.
Yes.
As it appears from the chronology of your dates,
Yes.
after the bill was sent to the governor
Ah.
and the period as per the Tamil Nadu judgment was over,
Yes.
if the government in power felt that it is a deemed consent, was it notified? Probably not.
No, but the whole purpose of deemed consent as we understood it.
No. So therefore,
Yes.
what we understand that therefore in July an ordinance was passed.
Yes. Yes.
So this government was also not under an impression that it was a deemed consent and therefore the necessity of a ordinance. Now ordinance is as good as law with its little time limit which it has for its life.
Yes.
So this is the first issue, that if the government thought about a deemed consent, it has not notified, but instead
May I just clarify, Malas? The
Yes.
bill which was sent for the governors and which we say is deemed assent is the 17th March 25 bill number 9 in my
right.
legislature. The ordinance is to the cognate parallel act regarding the Panchayati consequential act. That is the consequential act. I am putting this reservation into panchayats. Tomorrow I will put it into education. Day after into public service employment.
So then that
The amendment is the consequential thing where I want to place the reservations.
So then the 17th March bill, which was
Yes.
passed, was not notified as yet.
Whereas the bill is once it is deemed assent act, it is self-operative from the act.
Now, for the people to come to know that it is an act, there is a further act of notifying it in an extraordinary gazette to be made effective from a particular date.
Well, that the learned AG, I am told, has that document, whereas I don't have it. It was recognized and acted upon and known
Very
to the
well.
public.
Subject
That
to
is one.
clarification.
But your lordship may clarify that this ordinance is about the Panchayati consequential, not about this one.
Do you? We have not seen that July 2025 ordinance.
Yes.
But the 2 bills relating to amendments to the Panchayat Act and the Municipalities Act, which were passed in late August 2025 and have been sent to the governor, they are also awaiting assent. But
Yes. But the ordinance is on the record of this volume, page 121. Which I
very well. So does
121, volume 2.
the ordinance is for amendment to the Panchayat Act or Municipalities Act or both?
Panchayat Act.
Okay. So
That is the 2018 Act.
So the relevant provisions which were finally passed by the Legislative Assembly in late August, they were already promulgated by way of an ordinance in July 2025.
Correct.
Is that
correct.
very well? Secondly, judgments all of both sides have referred to in matters of reservation to these local bodies. There is a judgment of 3-judge bench in Gauli's case.
Yes.
Where the triple test has been reiterated.
So, I'm very grateful. The answer is there clearly, and we satisfied.
No,
Please turn to Gauli.
Let me first
articulate
the full question.
My apologies.
So, all the judgments in Indrasani or the later judgment which you referred to, they propose a general exception in exceptional circumstances that the sealing is not sacrosanct.
Obliged.
But the Gauli's case, in a case of a local body itself, says 50% is sacrosanct. Now, how does the state or any state for that matter get over it? All these ceiling limits which are being crossed by different states, they ultimately are being challenged and are being taken up.
I appreciate.
So this Gauli judgment.
May I answer, brothers?
And third, so that you may also think over the third issue. The local areas in which all these panchayats are there, they may have different proportion or demography or levels of representation or presence of backward classes. But this GO 9 uniformly applies that 42% across the state. Whereas if the empirical exercise is done like it was done, say, in some other state, then it could have been tailor-made to the requirement of different panchayat bodies in different districts for that matter, instead of a wholesale uniform 42%.
So
There, whether sufficient application of mind has gone into that or not by the commission or by the body collecting the data and the government which has accepted it.
yes, please. May I answer, please?
Fourth question.
May I answer, please? Just 2 minutes.
There is one more question which my brother rightly
Yes, yes.
that after this data etc. are published and the commission submits a report, is there not a requirement for publication and inviting objection and then dealing with the objection and accepting it?
Right, please. I appreciate it. May I answer, please?
Yes, yes.
So let me answer, please. First of all, let me take the last point.
Yes.
This is a exercise for a government to make a policy decision. Then on that policy decision to pass an act of parliament of a state legislature and then to implement it. It is not an exercise where it's a legislative exercise which translates an in-house exercise of collecting data into legislation to educate and inform yourself. There is no procedure under any statute or under any common law that an exercise to collect data for the demographic profile of your own state itself requires natural justice or hearing or inviting objections to decide the validity of the data you collected. That is one of the first answer. This is not an exercise where when I collect data, indeed it is not only an exercise that is not required, it is an exercise that can't be done because you are doing an intensive exercise which is to collect data to inform yourself to take policy decisions which are rational and reasonable. There is no question of individually hearing all these people.
There are judgments which have referred to this exercise of publication, inviting of objections and then acting upon it.
No, to that extent, whereas we have given those notices when we went to the survey. I just read to your lordship that just can you take volume 2? Volume 2 has that part where we have gone and informed people, but it is not the kind of exercise which your lordship has for an administrative decision making. It cannot be, Wallace, if I have to survey 97% of the population, there is no question of inviting objections. The very nature of the exercise is different. If your lordship sees that report which I showed, Wallace, it has to the extent, it has to involve people. It has,
collection of data.
Yes, that's all. And the collection of data cannot have any natural justice in the quasi-judicial sense. Come to Wallace, page 140. To the extent it requires a reasonable, informed, rational thing, it is there. It is very specifically written there. Come to 139, Wallace.
Yes.
139, relevant part at 141. Questions are made at 141. Then methodology means you create households and then enumerators and then supervisors for enumerators. Then you do house listing.
Yes, yes.
And then your lordship sees that page 140 last para, widespread consultations were held with all stakeholders. Their input suggestions were taken into account. There is no other form of quasi-judicial process required for this. I'm saying it's per se not required. And this can't be a ground to set aside or stay something.
Very good.
Second answer, that you do not have a individuation district-wise, as my Lord the Chief Justice rightly says, for the BC population. Well, that is absolutely true. No survey is applied in a state by applying a reservation of X% in district A and Y% in district B. It never can be, it never is. You have to live, because then there is no reason why to say that once you go to a district, you can also say that why don't you have a differentiation of individuation taluka wise, region wise, colony wise. These are always averages. It is always an average. It's an idea that the total population of a state is broadly X, Y, and Z. And we must mirror that X, Y, and Z in our policy making and our targeted incentives. If your lordship were to apply the test that ultimately the level below the state is district, then the level below the district is taluka, the level below the taluka is a block. There are wide variations. You will never be able to implement because you are doing a broad-based thing. And here the pluses cancel the minuses. It's the average which works. That's the only practical way for every survey. And any survey, well, no other survey has ever been struck down on the ground that you do not do an individuation of district-wise. That is number two. These are grounds which are, have to be 2 + 2 is 5, so perverse, unreasonable, and ad hoc that a lordship can state. Then, the third point, Gowlie's case, come to para 13. If your lordship were reading, wherever your lordship were reading it, come to para 13, SCC page 85. On the face of it, Gowlie is in my favor because it allows me, so long as I follow the procedure of Gowlie. Now, I'm sorry, before that I must say one thing, my apologies. Gowlie's 3 learned judges. So there are 2 submissions. First submission is, please don't read Gowlie as going over and beyond and in addition to the boundaries of either Indira Sani or Janit Abhiyan. Indira was 9, Janit Abhiyan was 5 judges. So,
but
ADMA not putting.
Gowlie judgment also considered Indira Sani.
No, they did, Malad. I'm coming to the actual. They had to, Malad, because Indira Sani is binding everywhere. Now,
yes.
My point, I have 3 answers to Gowlie, Malad. Gowlie, answer number 1. Gowlie can only be an implementation of Indira Sani and Janit. It cannot be laying down new law beyond and higher than or different from these 2 judgments. One is a 9 judge, one is a constitution bench. So please read it harmoniously. Number 2, if you read Gowlie harmoniously, then there cannot be a bar in panchayat elections. Because Indira Sani says there cannot be a bar, Janit says there cannot be a bar, Justice Bhatt and Justice Sawant quoted, which I read to say there can't be a bar, absolute bar. Whether it is valid in a particular case, yes, but there's no bar. Now, Gowlie says, now the third point of Gowlie, that you cannot have it unless you do the 3 conditions. To put it in a reverse way, Gowlie is saying you can do it, provided you follow 3. I hope I'm clear, Melissa.
Yes.
Now, what are those 3 conditions? That's exactly what I've done. In Gowlie, it was not done. Gowlie says you can do it. You can reserve beyond 50, provided you do these 3. Be that as it may, it is indisputable that the triple test conditions required to be complied with by the state before reserving seats has not been done so far. That was the problem. Now, what was that? 1, to set up a dedicated commission to conduct contemporaneous rigorous empirical inquiry into the nature and implication of the backwardness of social bodies. I hope my lord is clear, Maris.
Yes.
That is the fatal flaw in Gowlie, not in my case. Number 2, to specify the proportion of reservation required to be provisioned local body-wise in the light of the recommendation of the commission so as not to fall foul of the overbreadth. I have not 2, but I have got 3, Malis. The original data collection, the one-man commission, and the expert group, headed by a Supreme Court retired judge. Third, that committee, and I'm not talking of Supreme Court judge, I'm talking of real, genuine experts, worldwide known, Piketty, John Raj, Nikhil Dey, very well-known, eminent people. In any case, such reservation shall not exceed aggregate of 50% reserved in favor of STs taken together. In a given local body, the space for providing such reservation may be available. Now, Malas, this means, can it mean that your lordship is a bar on 50% above? Then there is no Indira Sani and Janit. I hope I'm clear, Malas. Gowlie cannot be meant to say that if you comply with the first 2, you still have to be within 50.
But we can't interpret it
But your lordships can interpret it harmoniously with Indra Sani and with Janit.
This
Your lordship is to interpret it harmoniously with Indra Sani, which I have read, with Janit, which I have read. Otherwise, it would mean that after Gauli, there is an absolute restriction permanently. You can't exceed 50%. Just see the last sentence, brothers. See, what was the purpose of Gauli? See the last 4 lines. Admittedly, the first step of establishing dedicated commission to undertake itself remains a mirage. I'm very important, my lord's query. My lords, read that last part.
Yes, yes.
Admittedly, the first step of establishing a dedicated commission to undertake a rigorous empirical inquiry itself remains a mirage. To put it differently, it will not be open to the respondent to justify the reservations for OBCs without fulfilling the triple test. The triple test is simple. A, collect data. B, have an expert commission. C, normally stick to 50%, but demonstrate by reference to 1 and 2 that you need to exceed 50%. Otherwise, it will make a mockery of the entire law. Your lordship will not read something rigidly in a manner as to be inflexible. And well, this is matter of and last, I'm sorry.
Yes.
Last point on Gauli is this the kind of clear 2 plus 2 error into 5 which will justify on the threshold without pleading the final hearing a stake? This is a matter of argument and interpretation at the highest. At the highest, your lordship needs much more than that after all the exercises done by a unanimous state government across the political spectrum in legislature and executive. Your lordship has the power of quashing it. Of course, your lordship does. That is very different from saying that this is so egregious, so blatant, so one-sided, so clearly ex facie 2 plus 2 is written as 5 or 4.5 that your lordship should be able to state. Those are my submissions. I'm extremely grateful.
Yes.
I'm extremely grateful. The election schedule has been declared, I am told, on 29th of September. That's the last point. I'll take a minute on. That paper will be handed over by Mr. Siddhi in volume 4. Please keep the page. Go to volume 4. Which page? Well, that may be a separate piece of paper otherwise. The schedule is on 29th of September. That's the last reason I'm saying your lordship does not normally interdict a schedule. It's an all-state election process. Again, nobody is saying that your lordship doesn't have the power to touch it. But your lordships will require something very special and very grave. As I said, patent illegality on the face of it. 2 plus 2, I gave the example. Otherwise, your lordship does not interfere with the election schedule notified on 29th of September. That schedule has been handed over, I hope, by Mr. Six. Mr.
Yes.
Siddhi. That's the last point. I'm very deeply obliged. There are any number of judgments, your lordship. No state of Goa may be handed over. You can't interfere once for this.
Where is the notification of this schedule of elections?
This one, 29th September, which is handed over, I think. Subject to correction by the AG's office, that is the one I have got. 29th of September. It says, annexure to notification dated 29th September. The actual notification may be handed over by my learned friend there. This is actually only the annexure. My lord, this is right. This is only the schedule.
Item number 24. Well, in item number 24, we have challenged the notification and that schedule.
That's all right. I'm not saying.
There's no gazette. The law requires it to be in a gazetted form, the notification. This is just a schedule.
And it's well known, I don't need to cite case law. State of Goa and many other judgments open it. 2021 8 SCC 401, 2021 8 SCC 401. Three learned judges speaking to Justice Nariman clearly say that a lordship will not interfere once this process is notified. The relevant para is 68 and the sub para 68.1 onwards in that para. 68. And this is related to municipal elections. I'm deeply obliged.
Hey,
Learned AG, is it notified this schedule?
Should be notified, my lord, I'll bring it to your lordship. It's notified. Should I have it tomorrow, my lord, I'll serve it.
Okay, give it a copy. Give a copy to us.
I think, my lord, it's not there. My lord, I'll produce tomorrow, my lord. I think, my lord, it is gazetted because that's what I have it, but I found out, my lord, that the gazetting is also there. Gazetting is also there of that, my lord, of that notification. Gazetting is there also. Gazetting is there. Yes.
I am appearing for the state. I am instructed to appear for the state. May I make my submissions? Just 10 minutes I'll take. I'll not take much.
It is not yet over. Verma, continue tomorrow.
So this is the notification. And secondly, after that, that 27th March 2025 bill passed by the Legislative Assembly sent to the governor. Thereafter, the plea is being taken that it's a deemed consent. Whether that has been notified as a law, the
I'll find out about that. That I don't have.
nobody knows about it.
How is this a notification?
We will conclude. We have already concluded. No more arguments on interim prayer.
I'll just take 10 minutes.
In that case, my lord,
I'll not repeat. I adopt the arguments of Singhvi. I'm also appearing for the state.
This is not. This is only for one district too. And he's giving for each state, each district separate.
Assent కాదు
21 6 SCC
198 క్లియర్ ఉంది ప్రజెంట్ పబ్లిక్ చేయాలి సారీ విడ్రా చేసుకుంటున్నా వాడు
That is a valid correct. I want it.
Okay, 21 6 SCC.
Elections are
So,
not.
Learned AG, apart from Mr. Singhvi, you are representing the state. Other councils are also.
Yes,
No,
I'm
and my lord, Mr. Verma is there, my lord. Three of us are appearing for the state.
appearing for the state.
Yes, yes. Please.
My lord, we'll
Please
make
make it short because we have.
My lord, I think, my lord, we'll have, it should be appropriate, my lord, if your lordship should continue for tomorrow because other friends are also there. My lord, I might take 10 to 15 minutes. My lord, the state need to be represented by the state, by the office of the state.
But there will be no end to it. We have heard the whole day.
No, my lord, your lordship, Not that, my lord.
It's not the final hearing.
I'm counting heads, my lord. Your lordship, please hear 2 or 3 counsels on the other side. My lord, it's the state which is important. The state needs to be heard by more than those people also. Because, my lord, what they want to do is they want to put a spoke in the election. My lord, we have to clarify to your lordship that spoke which they are trying to put is not correct.
We have no objection, my lord, as long as the state doesn't take further steps on this issue. The state needs to be heard. That's a fair statement by the learned AG.
About today and tomorrow, there can't be any other.
That's what exactly. That's what the learned AG.
Notification is already issued.
It is not issued. Sorry,
Such a
it's
statement
not a
was made
notification.
First time when the matter had come up.
If
My lord, apologize.
if that's not the way
Apologize.
proceedings are. Making a point, it is up for us to appreciate and do further hearing or not. Let him say whatever he is saying.
So tomorrow, my lord. Because, my lord, that's the notification. If your lordship will please to see insofar as the notification is concerned.
Lord, I would like to add only one sentence. First time when the matter came
No,
up.
you don't add now.
No, learned judge. No, learned AG has said. Learned AG is,
please,
no, learned AG assured nothing will happen till today. But some much water has flown up till today.
No, I did not say.
But he did assure. He did make an assurance.
So we keep it at 2:15 tomorrow, with the understanding that you and Mr. Ravi Verma
Mr. Verma.
would be arguing on behalf of the state, not repeating the argument what already said. And
Because not a word will be repeated. I'll simply adopt Dr. Singh's argument.
then we'll see some reply from the petitioners if at all.
See.
Where the petitioners are not being infringed a single fundamental right.
How can you say
And
that?
they have been filed the privilege petition, we will demonstrate along with the quantum of law of unaffected court before your lordship.
Complete petitioners will hear at the final hearing stage.
No, after completion of the state, my lord, after completion of the state.
My lord, I
Because
Complete-
single petition would
complete
not be,
petitioner,
would
complete
not be sustainable
respondents.
before your lordships.
Complete petitioners, complete respondents will hear at the final hearing stage. We had
No.
good consumption of
Lordship, sir.
submission
one
from
request, my lord. My lord,
My
one
humble
request.
submission.
from state side also.
Submission with the great respect to the honorable court, my lord.
Lordships,
And
one
the
request.
primary issues are there. that,
2:15
my lord,
tomorrow.
the petitioners are
Lordships,
not
one request, my
available.
lord. One request. My lord, I think the learned AG made a fair statement, my lord, that state needs to be heard. Let the, they have entitled as much right of hearing, if not greater right of hearing. But let them not make it further steps on this issue.
No, Malas, we are objecting completely. Malas, this
Notification
is
has
not a
not been
way.
issued.
Otherwise, Mr. Verma and Mr. Ely
The
refused to
nomination process starts, my lord.
This should not be an excuse to